Chair, I'd like to enter into the record the Center for American Progress report that says that it would cost $50 billion to deport the estimated 5 million people who would benefit under DACA and DAPA.
Without objection.
Professor Legomsky, critics argue that even though DAPA and DACA have individualized criteria that officers have to use on a case-by-case basis, that the high rate of approval for these programs shows that there's some sort of blanket approval of these cases. Professor, you served as the chief counsel of the USCIS in the Department of Homeland Security for several years, including during the time when DACA started. So I'm curious to hear what you learned about the adjudication process of these cases. I understand that USCIS reports a 95% approval for DACA applications. Can you explain why there is this high approval rate and whether it's appropriate or not appropriate to conclude that officers are not making individualized assessments?
Thank you. At first blush, I agree that 95% sounds high, but it's not when you think about who's actually applying for DACA and DAPA. If you're an undocumented immigrant, and if in addition you have some other negative conduct in your background, there are at least two things you're very unlikely to do. First of all, you're not going to initiate contact with the government and say, this is my name, this is where I live. I'm undocumented, and I also have this other negative thing in my background, and here are my fingerprints so that the FBI can do a background check on me. You're not likely to do that. Second, unless you're independently wealthy, and not many of these folks are, you're not going to send the government a check for $465 for something you're very unlikely to receive. So for both reasons, this tends to be a very self-selecting population, overwhelmingly people with rock-solid cases, and therefore the high approval rate in no way is evidence that these decisions are being rubber-stamped. And may I just add quickly also that the notion that they're being rubber-stamped would come as quite a surprise to the 38,000 people who have received denial notices.
Thank you for that. Professor, Congress mandates through the Secretary of Homeland Security the national immigration enforcement policies and priorities. Thus, in doing so, the Secretary has directed the agency to prioritize certain categories of people over other categories. In the Texas versus U.S. case, the Judge Hannon seems to accept that prosecutorial discretion is appropriate in this context. However, he seems to oppose the idea of granting deferred action and notifying the individuals that they are not an enforcement priority. Isn't deferred action in and of itself a form of exercising prosecutorial discretion? How would you counter Judge Hannon's reasoning?
Well, I agree with you. I think you're absolutely right. Deferred action is simply an exercise of prosecutorial discretion. The only thing that distinguishes it from some exercises is that the government is giving the person a piece of paper saying this is what we've decided to do. But I think with respect that Judge Hannon has confused the question of whether deferred action is legal with the question of whether these other benefits are legal once deferred action has been granted. If he objects to those other benefits, for example, the ones that are codified in the statute or in the regulations, then properly what he should be doing is advocate a change in those laws. But the President did not touch any of those. It's just deferred action.
Professor, in Judge Hannon's opinion, he argued that DHS acted unlawfully because he did not allow because it did not allow the public to comment about the new DAPA program in accordance with the Administrative Procedures Act. Can you walk us through whether DHS was required to follow the Administrative Procedures Act before implementing the DAPA program?
Yes, thank you. The APA notice and comment requirements by statute do not apply to general statements, general agency statements of policy, which the Supreme Court has expressly interpreted to include any guidance that the agency wants to give about how it plans to exercise one of its discretionary powers, which it has done here. So what this really turned on in this case was whether you believe DHS when they say we're exercising real discretion. Judge Hannon concludes that they were not, but the only evidence he cited was an unsupported statement by one USCIS agent, Kenneth Palinkas, whose support was simply they're being decided by service centers, which, by the way, is where the vast majority of USCIS adjudications are being decided. And he said, therefore, they must be getting rubber stamped. That simply doesn't follow. The adjudicators at the service centers, and I know this from personal experience, take great care to go over the documentation very carefully. There are FBI background checks and so on. And if there is any case in which they think that there would be some use in conducting a personal interview, then they can and will refer the person to an interview at a field office. So those are very careful adjudications. I don't know where he gets the idea that they are being rubber stamped.
Thank you. I yield back.